I believe from what I have read that you know a great deal about criminal law. And I've always thought, and please don't undelude me if I'm deluded, that the criminal law, when you think of it as a whole, you are trying to try people who have done something morally as well as legally wrong. And when you come across a case where the person has done, euthanasia is a possible example, they've done something that in the circumstances you think is morally right, even though it could be legally wrong, you hesitate. And sometimes you don't prosecute. Yeah. Okay? And there's an example. And you say, can I give a rule as to when this empathy or values or purposes or consequences, when they carry the day? No, I can't give a rule because each case is really different from the others. But I can say that you yourself, your colleagues, the lawyers, maybe even if you're very special or something, maybe history sometimes, will tell you if your decisions have been sound.
So I don't know, Justice Breyer, I don't know if you care a lot about crowd size, but and by the way, I shouldn't need to point out, we're in New York City on a Friday night. They had other options. But they're here for good reason. It's really an honor to be with you, Justice. Thank you for your service. I'm going to start with an easy question. What is it that a justice does? Is it just calling?
Question. Can you hear me with this microphone? Yes.
Is it just calling balls and strikes? Are you just an umpire?
Well, what do we do? But before that, I want to thank you for inviting me. I've been here once before. But I mean, you cannot be in this hall without... Is that better? You know, there are a lot of people, when you turn it on, they think it's worse. When you're here, you think of Abraham Lincoln.
I think you just need to hold it. No, you need to just hold it to your mouth.
Now do you hear it?
Yeah. Keep it there.
Would you prefer I turned it on? Yes, okay. I mean, you're in this place. You think of Abraham Lincoln. And he tells you something about a judge because he really gave this speech, the Cooper Union speech he gave after the Supreme Court had decided Dred Scott, probably the worst decision they ever made, that African Americans weren't citizens and really couldn't bring cases in court. The only justification I've ever heard for that decision is that Tawney, who gave the Chief Justice, gave the opinion, that Tawney thought it would end a political fight because the country wanted to know, could you have slavery over here in territories, in this territory and that, and he would make it clear that you could. Well, what that proves, which is a well-known thing, which is true today too, judges are terrible politicians. Really. Because Lincoln, when he read the dissent, which was Bradley, who was up from Massachusetts, he read that, he said, this case, he said, the holding, he said, it's a shocker. It's a shocker. And then he came here. And he gave that talk that vaulted him to the head of the Republican Party and probably assured him the nomination for president, which meant there would be a war, not that there wouldn't be. All right, I wasn't there. I didn't know Tawney, contrary to popular belief. But regardless. And Preet was U.S. attorney for years. My brother is a district court, a trial court judge in San Francisco. He says the only people who understand law are litigators and trial court judges. He said, you may think you do. He won't tell other Supreme Court justices that, but he does tell me that. He said, you might think you do. Well, all right, let's go on to a different subject. So thank you. And you want to know what I do. I like telling people what I do. I particularly like telling high school students. And I'll go down to the 7th grade and tell them if they'll listen. So what do I say to the 7th graders, what we do? I mean, they know we're appointed by the president, we're confirmed by the Senate, there are 9 of us and so forth. But what I want them to know, I say, here's the best example. Hard to get to them because they're looking out the window while I'm talking. But I'll say, look, I read in a French newspaper. It explains the whole thing. A biology professor is traveling from Nantes to Paris to meet his class, and he has in a little basket 20 live snails. Conductor comes up, looks in the basket, says, "Hey, do you have a ticket for the snails?" The professor says, "What are you talking about? Ticket for the snails?" He says, "Well, read the fare book. Here it says, no animals on the train unless they are in a basket and you buy a half-price ticket." So professor says, they're talking about dogs or cats, maybe a rabbit. They're not talking about snails. He says, "Well, is a snail an animal?" So I asked the class, is a snail an animal? And my God, you produce an argument. Some of them say, of course it's an animal. He has to buy a ticket. And the others say, are you kidding? What, you have to buy a ticket for a mosquito? You have to buy a ticket for a rabbit? I mean, yeah, or a fly or something? That's ridiculous. And they go on for about 5 minutes, and I say, now you know what we do on the Supreme Court. It's true. Words a little different. Law, freedom of speech, not animals. Same idea.
So how did the seventh graders decide?
Which
way did they come out?
The same way that judges decide.
No, but
we don't flip a coin.
But did he have to buy a ticket or not?
The newspaper wrote the article, and the result of it was that the company reimbursed the professor. Now, you know just as much about that as I do, which is nothing useful. Okay.
I mean, does it get appealed to like ninth grade? Like, how does that?
Yeah.
How does that?
Good point.
How does that work? Yeah. Remember, it's the Supreme Court, probably 11th grade. You say something else in the introduction to your book. I should repeat your book's name, Reading the Constitution, Why I Chose Pragmatism, Not Textualism. We'll get into what all those words mean and why you have made the choice that you have made. But you say, this book's organization, in a general sense, mirrors what I often tell students about a career in the law. That career asks you to exercise both your head and your heart. Everyone has a heart, but not everyone has a good head.
I'm not naming names.
Really?
Yeah.
Is it also true that everyone has a head, but not a good heart? And I ask that question because I wonder, for the role of a judge or a justice, is it more important to have a good head or a good heart?
Both are, really the truth is that both are important. Both are important. Both are important.
No, just hold it close to your mouth.
Okay, can you hear now? Yeah. Just hold it closer? Why didn't I think of that? I don't know, but you need both. Both are helpful. Both are helpful. And what I'm trying to explain in this book, there's a better title. Actually, they translated it into French. It's a better title in French. They talk about, they say, called the Constitution, the letter or the spirit. Yeah, that explains it better. The publisher got this one. It's perfectly good, but nobody knows what it means, which means actually more people will buy it but nonetheless, what we're trying to do is decide, is a snail an animal? No, not with those words, but the freedom of speech, the right to bear arms. What is the scope of those phrases? How far do they apply? What do they apply to? When do they apply? And the reason that there are law schools is sometimes questions like that and thousands of others are difficult to answer. So when I'm talking to the undergraduates, I say, why law school? I can't say it's the greatest thing to do. Maybe it should be architecture. We had a great architect, Harry Cobb, who designed our courthouse in Boston. And when he thought about the courthouse, and he spent several months listening to cases in the courthouse, he didn't think just about lines or just about spaces. He thought about spaces. He thought about lines. He thought about color. He thought about the experience of the people in the courthouse. He thought of their understanding. What is this courthouse for? What is this building about? But he also thought, there are human beings here, and they're going to come into work every day, and they're going to come in and see a case decided, and it may be their case, or they may be on a jury, or they may be a judge. But this is one institution among others in the United States that help us, the courthouse and the law that it represents, that help us, 330 million of us, live together a little more peacefully, a little more productively. And you want to keep that in mind. And you don't need to be a genius to understand that. But you do have to have a degree of empathy, a degree of sympathy, a degree of understanding what this building and what it stands for. What are they for, ultimately? And so I'll say you'll represent a client. You'll help them, we hope. And you also will represent this institution, just like the architects. You represent an institution that is there to help us live better together. I'm not trying to convince him to going to law school. I'm just explaining why, as he well knows. You need to have a heart as well as a head.
So some people might say that empathy, I don't say this, but some people might say empathy is an interesting value to exalt for a judge. And the question is, how does the value of empathy intersect with the value of neutrality?
I'm going to get what I say, because in here, if you read it, you'll see that I don't think you look at the words of this statute. We decide the meaning of the words of statutes. You look at the words of the Constitution. They're very, very relevant. If the word on that statute is fish, that doesn't mean a chicken. And don't pretend it does. But there's more than that to it. Because particularly in the Supreme Court, we only take cases probably, almost all the time. Lower courts have reached different decisions as to the application or the meaning of the same statutory or constitutional words. So it's difficult, and the words are unlikely to tell you the whole answer. So look to other things too. What? Well, somebody wrote those words in a statute. What did they have in mind? In the 18th century, they used to say, what's the mischief that these words are trying to cure? You might look at the consequences. If the consequences of this interpretation rather than that interpretation are pretty bad, take that into account when you're deciding the correct interpretation. You might look to values. What values? Well, we have a pretty good set of values in this document, the Constitution. And there are others. I believe, from what I have read, that you know a great deal about criminal law. And I've always thought, and please don't undelude me if I'm deluded, that the criminal law, when you think of it as a whole, you are trying to try people who have done something morally as well as legally wrong. And when you come across a case where the person has done, euthanasia is a possible example, they've done something that in the circumstances you think is morally right, even though it could be legally wrong, you hesitate. And sometimes you don't prosecute. Is there? Okay? And there's an example. And you say, can I give a rule as to when this empathy or values or purposes or consequences, when they carry the day? No, I can't give a rule because each case is really different from the others. But I can say that you yourself your colleagues, the lawyers, maybe even if you're very special or something, maybe history sometimes, will tell you if your decisions have been sound. What is it? Is it experience? Is it, sound? What's that? Works fairly well. Helps carry out the values in this. Is there a rule for it? I don't know the rule. I don't know the rule. Does that mean I just pick out whatever I think is good? Surely not. Surely not. I went to law school and I taught law and I've done a lot of things, and you will have too. By the time you're in your 40s, your 50s, your 60s, you've had a life. And that life has helped to shape you. And it's helped to shape those things that you consider to be more important and less important. And what you'll actually act on and what you won't. And you can say all you want. I try just to follow the law. And I say, yes, that's what I do. I try just to follow the law. But the law is not computer science. The law is not just a set of rules. The law is that which, as I've said 98,000 times, one instrument to help us live together more peacefully and more productively. And you know all those things. You read the briefs and you listen to the argument, and you have law clerks there to do research, and then you hear what your colleagues say and you listen to that too. And then you try to write an opinion, possibly, if it's assigned to you. That sounds trite, but it happens, in my opinion, it happens to be true.
Doesn't sound trite to me. You know, the way you talk about empathy, I sort of asked a false dichotomy in my question about empathy versus neutrality. Having empathy for someone, in my mind, in the criminal law that you invoked, doesn't necessarily mean that you're going to decide the case based on that empathy. It's an understanding, as you mentioned in your answer, that there are human beings involved and there are institutions involved and there are stakes that are very, very high for those people, sometimes the highest stakes moments of their lives. And to appreciate that is to have empathy and understand that your job is an important one, as yours has been. Speaking of the importance of the job and the difficulty of the job, I'm going to get back to interpretation in a moment. But something that's on a lot of people's minds, including folks in this room, presumably, is what is perceived as a threats to the judiciary. Threats to the judiciary. In some cases physical, but largely rhetorical. We have members of the United States Senate declaring that when the lowest level judge, a trial court federal judge, on a temporary motion, rules a way that they don't like, at least one has called it a judicial coup. There are prominent people who are talking about impeaching judges for opinions they don't like. What do you think about that?
What do you do when you get an opinion that you don't like? If from a district judge?
Well, we would appeal it.
Yes. Very simple. You appeal.
I rarely impeached the judge.
Good. Right. Another thing I explained to the class, I said, look, do you ever have any arguments? Yeah, the class says. Arguments with your brothers, your sisters, your parents, etc.? Yeah. You get over it? Yeah. How many arguments are there in the United States? I have no idea. 18 billion. Okay? Every year. We settle most of them. If you can't settle, you go to a person and he is called a what? An arbitrator. Oh, you're miles away from the arbitrator. Before you go to the arbitrator, who will charge you quite a lot, but before you go to the arbitrator, who do you go to? A lawyer. That's right. See, I'd rather you were an architect. I mean, being an architect is great, but not nonetheless. You go to a lawyer.
In terms of service.
What does the lawyer do?
I'm sorry, go ahead.
Good.
No, I said the person goes straight to arbitration, has read the terms of service.
Yeah.
It's like the only one.
I once asked the head of the International Arbitration Association, why are so many people going to arbitrators now instead of judges? He says, you don't want to hear the answer. So I said, no, I do. I'm curious. Is it that they're less expensive? He says, no, they're just as expensive. Is it that they take less time? No. He says they take just as much time, really. So I said, why do you go there? And he said, why aren't you in court? Why do you go to the arbitrator? He says, you really want to know? I said, yeah. He said, because they have better judges in arbitration. I said, no, I don't want to know. Okay. In any case, I once asked Justice Leakis, you see, you settle it. Maybe you go to a lawyer. He'll probably settle it. You can't settle it, which are just a few cases. You go to the steps of the courthouse, and what do you do on the steps of the courthouse? You settle it. And then on those few cases that you can't, you're in front of the judge and the jury. Jury decides the questions of fact, probably. The judge decides the questions of law, probably. One side wins, one side loses. And what does the lawyer think of the judge, the lawyer who loses? He never lost a case, so he doesn't know. What do you think? But
They don't like it.
they don't like it. This judge is an idiot. Do you say this judge is an idiot?
I would not say such a thing in front of 1,000 people.
No, no, of course not. So what do you do? Oh, by the way, what does the lawyer who wins think of the judge?
Genius.
No, he doesn't think of the judge. He thinks he's a good lawyer.
Yeah.
But in any case, as the losing lawyer, you
Appeal.
And if you lose on appeal, where do you go?
If you lose on appeal, you go further up.
Yeah, to a higher court.
The court
You
you're
go to a
familiar
higher
with.
and higher and higher court. And finally, there's no place to go but the Supreme Court. And they have a choice whether they take it or not. So and we only would decide questions with a federal issue in them. That's Congress's law or the Constitution, maybe. And maybe there are 80,000, 90,000 out of those 28 billion arguments that get to the highest court before the Supreme Court, and they ask us to hear the case, and we get about 8,000 requests a year, and that's about 150 a week, and the law clerks write memos on what their briefs are, and then you read those memos so you can read the briefs too. And then you vote at conference, and 4 votes means we're going to hear the case. And fewer than 4, no. And then they start writing. That's what it is. So what I end up with each case, I get a blue brief, petitioner, red brief. The judge was right. Petitioner said he was wrong. A yellow brief. See, they think we're sort of stupid, so they color code it. A yellow brief. That's the reply brief. I always read that first because it says the same thing as the others, but it's shorter. Okay. Then we have light green. That's the petition. You can file one. Light green or the amici for the petitioner. Dark green, amici for the respondent. And the government may file. You probably got them to file briefs, and they're gray. The government's always gray. I don't know. But those are the briefs. Now, why are they called briefs? They're not brief, but regardless, we read them. And then my law clerk will write a memo, and then we'll go into oral argument, and the oral argument will be for us, the judges, to ask questions. If you had a great argument, why didn't you put it in the brief? It's long enough. All right, but in any case, within 2 or 3 days, we're in conference, a table, we're there by ourselves. We go around, discuss the case, 5 minutes or 10 minutes, in order. Nobody speaks twice till everybody's spoken once. An excellent rule for a small group. And for me, I was the junior justice. I spoke last for 11 years. I missed by 11 days being the greatest, longest junior justice ever. Justice Story holds that. I thought of writing to Alito and say, can you wait 12 days to be sworn in? I said, then I can go down in history as the answer to a trivia question. But okay, and after you go around and you write down what you want in a book about what the other people are saying, after, there's back and forth. And by the way, and I think this is important, back and forth. Don't sit there and say something which they'll understand instantly if you say it. I have a better argument than you, ha ha ha. What that kind of response does is it produces on the other side, I have a better argument than you, ha ha ha. Okay, you get nowhere. So listen to what they say. And when you listen to what they say, then out of that, sometimes you can get some agreement, some change, and an opinion that is a better opinion because it reflects a broader point of view. Okay, now you understand the entire Supreme Court.
But that United States senator does not.
The United States Senate is different.
Okay.
It's different in this way. It's different in this way. When we both worked. We both
worked in the Senate.
Yeah, we worked in the Senate.
Separated by a little bit of time.
Didn't you like it?
I did.
I did too. I thought that's the greatest job I had, actually.
But neither you nor I
Right.
heard a senator back in the old days say about a district court judge's decision, that's a judicial coup. Is there something different in the air and the water now?
They can say what they want in the Senate. I mean, anybody can say what he wants. That's his opinion. Fine. I don't know the
But
decision.
do you have an opinion on their opinion?
What?
Do you have an opinion on that opinion?
Do I have an opinion on what?
Do you have an opinion on that senator's opinion?
I don't know who he's talking about.
Mike Lee.
If he's trying to, if there are district judges, my brother won't admit it, perhaps, but I will admit it on his behalf, and I will admit it on my own behalf. We make mistakes. People do make mistakes. After all, there are dissents in the Supreme Court. Somebody's right, somebody's wrong. After all, there are appeals, and sometimes those appellants win. Somebody was right, somebody was wrong. Okay, so you make mistakes. That's why it's a complex system. And what's the difference with the Senate? One day I get a phone call when I'm the chief counsel. It's Warren Burger, the Chief Justice of the United States. I think, hey, I'm a staff person. Why is he calling me? And the answer to that question was because nobody else in the Senate would talk to him. Why? Because they're busy talking to constituents or other senators or maybe somebody in the administration. And Harold Wilson once said in England, in politics, a week is a long time. And he was corrected because whoever corrected him said, no, a day is a long time. That's not true of the judiciary. There, you measure time in weeks, maybe months, and you're looking out into the future, in many opinions, before you write, before you put those words on the paper. The time frame is so different, and it makes it hard for them to understand each other.
Let's talk about reading the Constitution and also statutes. Your book is about both things. So you talked about textualism. For the non-lawyers in the audience, could you give a brief explanation in a way that's as generous as you might want to be to that mode of interpretation? Textualism, as I understand it, is simply an adherence to the principle that you look at the language and you decide what the plain meaning of that language is. Sometimes you use a dictionary, sometimes you don't need a dictionary. And people in the audience might ask, that seems reasonable. What's wrong with that?
Sounds good. It makes great promises. Read the text. Justice Scalia and I, who was a good friend, we used to debate these in college audiences. We loved it. We had a very good time. The students would come away thinking, oh, they are good friends. They just don't agree. And I would say to him, to help to answer your question, you get questions that the founders didn't know when they wrote these texts. George Washington didn't know about the internet. And you know what Scalia would say about that? He'd say, I knew that. And then he would say, it's more like the two campers. You know the two campers? One's putting on his running shoes. And the other says, what are you doing that for? And he says, I'm doing it. There's a bear in the camp. He says, you can't outrun a bear. He says, yeah, but I can outrun you. And he says, he doesn't think his system's perfect. He doesn't think just looking at what the founders thought when they wrote those words or what they would have meant to somebody at the time or what they mean now and the whole story. He says, I know that isn't perfect. But your system, Stephen, and you heard a little bit of it, is so complicated, you're the only one who can do it. And you may not be able to, he means. All right. So I say, that's perhaps true. I don't know. But I do know judges have done it that I've admired. Holmes, Brandeis, Cardoza, Hand, right here in Central Park. He gave a great speech about it. I said, but regardless, your system, Nina, will produce a constitution no one would want. Who's right? We really don't know, if we're honest. Maybe 10 or 15 or 20 years from now, people will decide. They say, why not just read the text? Why not? I say, because in most cases doesn't give you an answer. Here, what's a case? Take a case. I tried to find them in here because I wanted to use examples. I want to use examples because the professors, of whom you now are one, probably know 14 times as much theory about these things as I do. But I have had some experience they haven't had. And I want to put examples in here. Examples so you can see what I'm talking about. The textualists have come along and they've said, well, it's easy. And besides, it'll produce uniform results across the country. And besides, Congress will like it because they know what their drafting will mean. And besides, it will prevent you, Stephen, and others from writing into the law what you think is good as a substitute for the law. And I will say those are great promises. Those are great promises. I just think you can't carry them out. Example. The case. Many of you know that if you unfortunately have a child with a handicap, the school board, public school board, has to give them special education. And if you think they're not doing a good job, you can bring a lawsuit. And if you win that lawsuit, they have to improve the education. But it also says, and this is the key word, it also says you can recover your costs. Got it? Costs. So the issue in the case in front of us was, by costs, do they mean costs of educational experts? $29,000 for the woman in front of us. Or do they just mean lawyers' fees? Those can be pretty hefty too. Or do they mean just the court costs, filing fees? What do they mean? So I say to Nina or the others, what does it mean? It says costs. I'm supposed to just look at the word? Okay, I'll look at it. You know what it says? Costs. I say, oh, look at it harder. Okay. Costs. Got it. Look at it again and again. Costs, costs, costs. All right, I got it. Okay, now, I say, how does that help? Let's go back. And there are many, many cases. I could keep you here all night, but I won't. Don't worry. Hey, lots of cases like that. Lots and lots. If it were so easy, why did the lower courts split? And so you're saying, and I don't object to your saying, look at the words. Of course, look at the words. But look at other things too, such as purposes, such as what I said, consequences, such as values. And they all may, in an appropriate case, play a role. And will I just try to substitute what I think is good? No. I'll do my best. As I said, you can't jump out of your own skin, and you've had 40 or 50 or 60 years of skin. And people do have different views about how difficult cases in law should come out, and different tools.
So in fairness to the textualists, if the language is ambiguous, how can they claim that they're only looking at the language and not something else? How do you come up with a decision? How did Scalia come up with his opinion and his view in instances like the one you just described, where to an ordinary ear, the language is ambiguous?
No, because I simplified it, because he'll say, if you really can't tell at all, he says, you usually can tell. Let's look what most people would have thought at the time. But sometimes you can't. And if you can't, you look to, and this is the word they use, semantic considerations. So
that sounds bad.
Those semantic considerations are good because they have to do with language. See? So they have canons, these things called the canons. And they think canons like, what's a canon? One not in law is too many cooks spoil the broth. That's not actually a legal canon. But that's the idea. And they think that may sometimes help them. Yeah. I don't think it does help too often. Sometimes I can't say never. And they will take, what's the context? But they're very interested in the linguistic context. And they will try to keep to linguistic context, semantics. Are there other words in this statute which are the same as this word, and what do they mean? And what is the history of the use of this word in other statutes, and things like that.
So we understand the ordinary textualist, when they say look at the words and what they mean, are they referring to the meaning that they believe was intended by the people who wrote the words, or the meaning that is understood by ordinary people who read the words?
I think Nino, there are different kinds of
'Cause
textualists.
those are different things, right?
Yeah, those are different things, and some think the one and the other. I think Nino tended to think, what would the ordinary person have thought these words meant in this context in 1789 or 1870 or something? And I immediately say, though, I'll tell you something you might not have thought of, but I suspect you did. Let's go back to 1789 in our minds.
Do we have?
No. Let's think about that. Or even 18. There were a group of people who didn't really participate in the political process at that time. Let's think of who they were. I'll give you a hint. 5 letters, begins with a W and ends with an N. Okay? And what about the slaves, too? So why would we just look to what a small segment of our current population equivalent would have been thinking? And but that's naturally, I love my own arguments, and there are others who
another guy does too.
Yeah.
Okay, so you focus on, as you call it, pragmatism, which has many things that are components of pragmatism, one of which is to ask the question, why? What's the underlying purpose behind the words, whether they're deemed to be ambiguous or not? What's wrong with that? That sounds very reasonable too.
Yeah, it does sound reasonable. But there you have to go back and say, for one thing, probably in college I took philosophy, and one of the things we learned at Stanford or wherever it was, it was called American pragmatism. And it wasn't quite the same thing. People didn't just mean what's good. American pragmatists purse. And Holmes would go every Saturday to the Saturday club where Peirce was. And he was Justice Holmes was a pragmatist, and in that sense. And Quine at Harvard wrote a good book about it. But what it comes down to is we live in a world after the age of 2 or 3, when we've learned how to talk, where there are all kinds of institutions. And what you do over here can affect this one over there. And you better be careful that you do your best not to cause too much trouble with your decisions. You better be careful that overall you do your best to see that law really does point, at least, in the direction that I learned from 2 very good philosophers of law, in the direction that it should point in, which is to help those 330 million people, to help those 330 million people live together peacefully and productively. And that, I think, is what accounts for my belief. I can't prove it, but my belief that and my goodness, we need it. And that it will help more than just reading those words. I mean,
so a lot of critics of the court and particular justices and particular opinions will say, you know what, cynically, a justice chooses a mode of interpretation, whether it's originalism with respect to the Constitution, textualism with respect to statutes, pragmatism, you name it. The cynical view is that's just window dressing to reach a preferred outcome. And I wonder if you agree that a test of the integrity of a mode of interpretation is perhaps the frequency with which that leads to an outcome that is not necessarily the policy preference of the justice. And you point out in your introduction, quote, "This is not to say my purpose-oriented approach is merely a matter of choosing which outcome I believe to be the best in any given case. I have, for example, sided with a majority of the court in affirming a death penalty sentence I believed undesirable, and in denying the ability of an incarcerated person to bring a claim in federal court. And you go on to say, I did not do so because I believe those outcomes best as a matter of policy. Is that a good test for the integrity of a mode of interpretation or not?
Hard to say. What you're doing, that's a good way of putting it. But normally, when I get a question like that, it's not that question put so carefully. It's all politics, isn't it? It's all just politics. You write this stuff and they write their stuff, but really it's just all politics. We want the outcome, you say. And I say to that, and politics is a good word because I can refute it more easily. And no, it's not politics. Nor is it how many times you get outcomes, you decide with outcomes you don't like. Nobody keeps track of that. I don't keep track of that. I know since I wrote an opinion about the problems with the death penalty, I'm fair. I feel it's fair for me to say I've decided many cases where I voted in favor of the death penalty because that was the law as it was then, and I want, etc. But that is sort of a test. But it's important, I think, right now to understand that the Supreme Court is not politics. What is it? You say, skeptic. What is it? I say, these disagreements. Look, it's 100% politics or 98% when there's a vacancy and a politically oriented group tries to get to the president to suggest somebody. But they're suggesting a person for political reasons, a person who will likely apply a system, a way of looking at legal cases that will lead to outcomes that those political people favor. And you see, that's a little complicated. But what it basically means is that, the political people are looking at the politics, but the judges don't think that they're deciding via politics. The judges think that they're deciding, for example, by using certain theorems of originalism or textualism or some other approach. That's what they think. But look, there's a little hesitancy in my voice, isn't there? Why? Well, that is what they think. Well, look, when for a while after being appointed, I thought, look, I grew up in San Francisco. I lived most of my life up in Cambridge and Boston. Why do people disagree with me, who am so reasonable? And then after a while, I began to think, this is a big country. It's a big country. And people think all kinds of things in this country. My mother used to say that in San Francisco. She said, there's no view so crazy that there isn't somebody in this country who doesn't hold it. And she said, they all live in Los Angeles. Don't tell anyone I said that. But you see the point? And they've had different lives. And it's not so terrible to have people who've had different kinds of upbringing, different kinds of background, who've had different kinds of experience. Thurgood Marshall said that. And he was right. Not so terrible. So you can get them to try to keep that down, and you decide according to the more purely legal, well, you can't get it down entirely. So you will find people thinking different things. And more than that, it was best put, politics in the court, I think, by Paul Freund, who was a great constitutional law professor. He said, no judge decides a case based on the temperature of the day. And you can see that. If you have a criminal case, you don't want the judge looking over his shoulder. Right?
But the rest of the phrase.
Well, every judge, however, he said, is aware of the climate of the season. And what does that mean? The very fact that you're not certain and I'm not certain shows how good it is. You see? Yeah. I mean, if they weren't, how did we ever get from Lochner cases that said that you couldn't have minimum wage laws, that you couldn't have maximum hour laws, to a New Deal court? A New Deal court that approved a tremendous shift of power to Washington and the agencies. But how much? How much? And no one knows. Do you ever read P.G. Wodehouse? Yeah, good. Do it. Put you in a good mood. Very funny. But his hero, Bertie, he says, Bertie woke up one morning and he wasn't disgruntled, but he wasn't exactly gruntled either. Okay, there you are. And when I'm teaching a class, as I do, I say, well, maybe after a whole semester, we're getting into an idea of this, but please. And remember this, a great trial lawyer, F. Lee Bailey. He said, you want to be a great trial lawyer? You have to believe in your client's cause. You have to understand where he's coming from, and you have to believe in it when you advocate it. You believe in it, but not too much. Right? Okay. So you see, I'm painting an area. I mean, and you must have to do that if you're designing things. And it isn't exactly clear, but it isn't totally not clear. And so there we are. I can't say more about it, except that the common view that this is all politics, you're just doing what you want, that's wrong. That's not the way to put it. That's not the 28 years that I've been through in that court, or the 12 before. So I'll leave it to you.
Why is pragmatism necessarily identified with the progressive side and not the conservative side, or do I have that wrong? Conservatives often in the political sphere talk about common sense. I understand your pragmatism to be a little bit about common sense.
Mm-hmm. I do too.
So are there any
Well, but,
are there any ideologically conservative judges or justices who embrace pragmatism?
they could.
So that's a no.
No, it's there. I think we're an artifact of history. You see, there are people who didn't like some of the things that the Warren Court did. Nobody, not anybody's going to complain about Brown versus Board. So they think that's a good thing. And then they have to work out and trying to get away from certain other things that they don't think were appropriate. You see, I usually name someone who no one would think was a great legal thinker, but maybe there were great legal thinkers. I don't know. And there's some of them, they came up with this textualism business and the originalism and so forth. Okay, that's what they want to do. I'll say, well, they're wrong. So I don't have a good answer to your question. But I think what we'll see over time, and I think we're seeing it already, is that people who claim to be textualists or originalists actually come across cases where they have to admit it doesn't work. And they do sometimes shift sides. And we've seen that. We saw that, I thought, in the case that came out fairly recently that said you can't have a gun if you're involved in spousal abuse. And the court upheld that. They upheld it, and they did it for textualist reasons. And they wrote 5 different opinions as to how textualism got to this result. So I just say, fine, if you have to write 5 opinions to explain what your theory is, you don't have one. But so I think there's
a coherence problem.
Yeah, I think there'll be a movement where some of these things like purpose, and Roberts has written that. He's written that about textualism. He believes, but look to purposes too. Or maybe he's done some where you look to consequences. So I don't think that this is, but I don't know. Yogi Berra, Don't ask me. I never answer. Whatever it is.
So, Justice, you've made clear that you will not give your opinion or conclusions about cases that are pending. But I did ask you backstage if I could ask a question about how you would approach, under a pragmatic theory that you espouse and develop in the book, how you might think about approaching the question without deciding the question. Because I know you will say, I haven't read the briefs.
No. It's
so on this question of birthright citizenship, the 14th Amendment, Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Again, I'm not asking you to decide the question. How would a pragmatist, rather than a textualist, approach the question that's been posed?
I don't know if they'd approach it differently or not. What's interesting about the question, which I think is a good question, to to me is I've talked to groups of business people, and maybe architects are the same. When you have a difficult question, you have to decide something, not about yourself. Because once that's about yourself, God only knows. But not about yourself, but it's difficult and important. Okay, what I think happens in most instances, I pick up those briefs. I read the blue brief. No, first I read the question. It puts that question.
You read the yellow brief.
I don't always tell the truth when the thing is funny. But you say, look,
I just want you to know I was paying attention.
Yeah, the yellow brief has the question in it too. So I read the question. When I read the question, I know the answer. Then I read the whole brief. Then when I finish reading it, I think how right I was. Then I read the red brief. And as I get towards the end of the red brief, I think, not so fast. Not so fast. And then maybe it's the yellow, maybe it's blue, maybe it's the government, maybe it's some of the amici. And yeah, being open-minded, in my opinion, is not having a blank mind. It's being willing to change your mind when you're confronted with facts or arguments or other points of view that you didn't really think about. Or maybe you thought about it, but you didn't give it proper weight. And so by the time you're finished the briefs, you're beginning to gel a little bit, and it might not be the way you first thought. And then you have your law clerks who've written a memo looking up the points you didn't know about or uncertain. And then when I'd talk to them, the four of them, we'd have conversations with everybody present. I wanted everybody there. And then we go into oral argument. And you're gelling. It's pretty well made up, but that oral argument, which is really there for the judges. I mean, if you had a good argument, why didn't you put it in the brief? And it's there for the judges to ask questions and get clarification on things they weren't certain about. And a good question is a question you do not know the answer to. You think the lawyer knows more about it, and you think it might matter to your decision. And that oral argument probably will only rarely change your result in the whole court from opposite, but it will often change how the judge looks at the case. And how the judge looks at the case matters for the way it's written, and the way it's written has a lot to do with the law. What is the law really about? And you're pretty much made up your mind when you go into the conference, but minds sometimes change. Sometimes they change completely. And sometimes that conversation will at least get in the forefront a point that maybe wasn't in the forefront when people walked into the room. And then the case is assigned to one person to write. Everybody writes one, then two, then three, etc. But by the writing, then my law clerk there will go out and look up everything in sight and come in with a memo or a draft or whatever, and I'll read it because I was a professor. I can't resist sitting at the word processor, and I write the first word. And for anyone who's done teaching, as you know, you write the first word, you write the second word. And pretty soon you've written a lot of words. And pretty soon it's not quite the same. You give it back to my law clerk. She thinks hers was better, but I say, all right, there we are. And then you go back and forth. And then you send it around. And I'm waiting for a reply. And all I want, I'll tell you, I don't want a reply that says this is the most greatest thing since sliced bread. All I want are two words: I join. And once you get those 5, now it's the court's opinion. Now, many will say, I'll join if. And you try to make those decisions. You can't always. And that is a big question. Can I make this change or not? And that's a hard question. Often. You try. What the country's really interested in is not the Constitution according to me or according to Sandra O'Connor or according to Nino Scalia. What it's interested in is what does the Constitution mean according to the Supreme Court? And you remember that. Because Clinton told me this. He said, you'll see, the applause will die away. And it dies away a lot faster than you think. So you better like the job. And that is the privilege of the job. The privilege of the job is that you can sit there day after day and give your best to this case or that case, because that means something, at least to a few people and sometimes to a lot of people. And to be able to spend a long time in your career doing that, that's a privilege. That's close to where you are as U.S. Attorney.
Yeah. So you dissent often, as do many justices on the Supreme Court and judges on appellate panels throughout the country. Sometimes the differences of opinion between and among justices are quite stark. And a layperson reading them wonders, what some of the justices think of the other justices. And these are not, I'm not going to ask you that question. And these are not small matters that go up to the Supreme Court of the United States of America. These are cases that have great impact, whether it's Dobbs or the death penalty or anything else, on people's lives and livelihoods. And you can expect people to feel very strongly about those things. And yet, to a person on the Supreme Court, there is always the declaration that we're good friends and we're colleagues, and there are famous friendships. You've had some from the other side of the ideological spectrum. Famously, Justice Ginsburg and Justice Scalia are good friends. And my question is, it's a two-part question. A, how can that be? And B, and I know you've opined on this, is there something there that's a model for us ordinary folks who are not on the Supreme Court to live and work together in this country that's very polarized, where people have very, very different views from what my views might be or another person's views might be?
I can say which is true. I mean, but I was there for 28 years. I do not recall, and I do not believe there was an instance in the conference room where a voice was raised, where one judge said something insulting or rude or even in a funny way about another. It's very professional. You do your job. And that's what I found. So when people say that's true, I think that's my experience. That was my experience. And some people made it lighter than others. I mean, one time I asked Rehnquist, we'd have lunch after, and I said, it's amazing. Here we are having lunch together, and people get on perfectly well, and they'll say something funny, or they'll tell a joke or whatever it was, or talk about some sports team, or talk about something else. I said, and just half an hour ago, and Rehnquist said, I know. Half an hour ago, half the court, different half in each case, thought the other half was totally out of its mind. Yeah, it can be done. And where do I think the person who emphasized that, maybe Senator Kennedy. When I worked for him, I loved working for him. He was fun. And he told the staff, hey, don't worry about the credit. Don't try to get credit for yourself. He said, if you succeed at achieving something, there'll be plenty of credit to go around. And if you don't, if it's bad, who wants the credit? Quite right. But he said, when you run into difficulty, what do you basically think? I heard him say one time, he was up at Hyannis, and the whole staff over the years was there, a large number. And he said this, and it wasn't written for him either. He said, my father told me that what you do, I think he meant in life, he said, you try to get people working with you, and you try to get them to help. Who will they help? They'll help themselves. They'll help me, Senator Kennedy. And they'll help somebody out there. Some group of people out there. Some group of people that need some help. And that's what he thought. So he would say, here's what you do. Here's what you do when we're trying to get a bill through or we're trying to stop a bill, or we're trying to do something, and we have some opposition. And John Stuart Mill, I later read, said something like this. I doubt that he knew that. I didn't know it. But in any case, he said, here's what you do. You go and find someone whom you think is intelligent and who actually does disagree with you. And you sit down and you talk to them. Wait, don't talk too much. Listen. Listen. And if they talk long enough, in many instances, they will say something that you really agree with. And when they say something that you really agree with, you say, stop. That's a good point you made. Let's see if we can work with that. And if you do work with it, suppose you get 30% of what you want. Take it. Take the 30%. Don't hold out for 100%, which you won't get. Don't hold out so your normal applauders and followers will say how great you are for getting nothing. You take the 30%. And I saw him many times when he did achieve something, and we did get something, and the press is there. And the press says, Senator Kennedy, you did such a good job on this. And Kennedy would say, don't thank me. Thank Orrin Hatch, the Republican. He's the one who came up with the idea that got us together. You see? Yeah. Shall I say what gives me hope?
Let me pose the question.
Okay, you have to pose the question.
Final question. To set the stage, a lot of people don't feel good about things. When people ask the question, I've had this conversation with many people, maybe it'll resonate with you. People ask the simple question, because it's custom, how you doing? Sometimes the answer is like 25 minutes long. In the hallway, I don't know if your Supreme Court gig came with a 401k. Don't check that today or probably Monday. And now, are you yet and still optimistic, sir?
Well, one, don't ask me about the stock market unless you're insane. I mean, I'm not the one to ask. But I'm a little less optimistic than I have been. But I can tell you what makes me optimistic. What makes me optimistic is what I told you about Senator Kennedy. And almost word for word, really, I've said before. And I like telling that particularly to those 7th graders or maybe the high school students, the 8th graders. And what makes me optimistic is not that which I just told you. What makes me optimistic is when I say approximately the same thing. Suddenly, those high school students, or even 7th, they're not at the window anymore. They're actually interested. They're actually interested. And they've heard something about when I was in the 5th grade at Grant School, and Mrs. Quataguatsa said, I'm going to divide you into groups of 4, and you're going to write about the city, and I'll give 1 grade to each group of 4. Hey, that teaches you cooperation. And during COVID, there were groups who went around Cambridge and tried to figure out how old people were doing, and did they need some food, or did they need... And that took place in cities across the country, and we're not too bad at getting together. And that's what I say. And they're not at the window. They're listening. And it's the look in their eye. It's the look in their eye. I don't think I'm making that up. I think that look in their eyes says that they've found something they can do to help. And maybe it'll be 10 years. I don't know how long it'll be. But those students will grow up. And if they get out there and participate, and I believe they will, and I think that's important, maybe they'll remember a little bit, or at least they want to. At least they want to maintain this nation as a nation, that's from my point of view, rule of law, but let's call it law, which is one instrument, one tool among many that helps the 330 million people live together peacefully and with a hope of prosperity.
Justice Breyer, thank you for being here. Thank you for your service to the country. Thank you for your wisdom. Thank you for your words and your optimism. And thank you all for coming.
Thank you. Thank you.